I'd like to give each of you maybe 30 seconds to just sum up with some key takeaways. We'll do it in the order of presentation. We'll start with Chip Collins. Chip, anything you'd like to add as a key takeaway?
Sure. Three key points. I already mentioned the first one, but that is every business should conduct a periodic trade secret audit. The second is that a DTSA claim should just be one of many that is considered in the instance of unfair competition. There may be reasons to add it in, and as mentioned by the panel, there may be reasons not to assert a claim, even if you could. And then finally, in litigating DTSA claims, attorneys, especially here in the early years of this statute, when we don't have a body of appellate law, litigators should look not only to reported district court decisions, but also common law cases interpreting the Uniform Trade Secret Act state statutes, and also cases interpreting the federal criminal trade secret statute. All can be sources for helpful authority.
Thank you, Chip Collins. Thank you very much. Joshua Salinas, 30 seconds for some key takeaways, please.
Thanks. I think one key takeaway to add on to what Chip just mentioned regarding the importance of trade secret audits. I think one helpful recommendation is to include multiple departments within the company when using that audit. It's when you're having different people from different departments, it's really helpful for not only identifying the location of that information, but knowing which employees at various levels have access to that information. And then with regards to restrictive covenants, they are going to vary by jurisdiction, but they can be an effective proactive measure to protect valuable company assets, including trade secrets. But you do have to consider that because these states vary, that there may be public policy considerations for the enforceability of those covenants. But even without a specific express restrictive covenant, courts are willing to provide orders under the DTSA, provided you can satisfy those preliminary injunction standards, but issue orders that would provide similar competitive restrictions.
Thank you, Joshua Salinas. Thomas Dye, some key takeaways?
Just to follow up, I've probably used my time on the last one, so I'll turn it over to Sean in a second. But to follow up on a point that Josh just made, in addition to identifying the trade secrets to involve people from different areas of the corporation or business, because they obviously know what's going on in their division or department, but also in developing restrictive measures, it's not something that can be just turned over to the IT department, as many people would like to do, or even a security department. Really, HR needs to be involved, legal, the product development areas, the marketing areas, because all of these different areas may have trade secrets, and all of them may have ways that the trade secrets can become not secret through disclosure, either accidental or marketing or on a website or otherwise, and therefore it needs to be a team effort within a corporation or business, because each department could have different trade secrets, and each might have different solutions to the problem, and so it's not one that can be solved but just by IT, but needs to involve everyone or people from every sector of the corporation.
Thank you, Mr. Dye. Sean Fox?
Yeah, I think the key takeaway would be, you have lots of flexibility when you calculate the damages, but the cases are very complex. So when you think about, the sphere of damages that are available, the focus is really on the plaintiff's actual loss, primarily the lost profits, the defendant's unjust enrichment, measuring that gain realized by the defendant. You can also look at the valuation of trade secrets and reasonable royalty.